Initial appearance section. I'm Judge Allen, Faye Allen, presiding. State, announce your presence.
Taylor Fleming on behalf of the Office of the State Attorney.
Thank you, ma'am. Defense.
I believe she's still in the back, Your Honor.
Oh, sorry. Did she know I was, oh, well, actually, the court's gonna
I texted her.
stay in recess until the defense attorney arrives. Defense.
Letitia George on behalf of the Office of the Public Defender.
We'll be appointing the public defender on all cases unless otherwise noted. Aristobal Felipe Ortiz, does he need the interpreter?
He didn't come over, he's not restricted movement.
Okay,
Which case?
was set for an arraignment?
Oh, we're doing arraignments first. I will waive and enter plea of not guilty, Your Honor.
All right, plea of not guilty entered. Madam Clerk, are you ready? The arraignments? There are two arraignments.
I mean, the dates. Right there in the bill.
I left my papers in the and my other papers.
Case be heard in Division 61.
Right?
All right, set for pretrial conference in Division 61, public defender is appointed.
Date is, December the 15th at 8:30, courtroom 12C.
Henry Jackson.
He's also on restricted movement.
Public defender was previously appointed on that case. Ms. George, do you want me to
VOP.
waive his appearance and enter a plea of not not admitting to the violation of probation?
Yes, Your Honor.
All right, the case will be set for a VOP status.
Case be heard in Division 62, VOP status, December the 12th at 8:30, courtroom 12C.
Carlos Rosario. You said no interpreter needed? Okay. All right, Mr. Rosario, in your case, the court finds probable cause for sexual battery on a child under the age of 12, and the court is ordering no bond. As a condition of release, the court is ordering you to have no contact with minor children under the age of 18, not to return to the location where this incident occurred, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. I've appointed the public defender to represent you, sir. Thank you, sir. Carlos Guerrero. Mr. Guerrero, sir, in your case, the court finds probable cause for trespass on property after a warning. The public defender is appointed.
Your Honor, there was an offer from the state of an adjudication of guilt, 5 days in the Orange County Jail with credit for 2, and no return to 4704 South Orange Blossom Trail, as well as court costs. Mr. Guerrero would like to accept and enter plea of no contest.
No contest.
Thank you.
Your Honor, the reason for the 5 days is he recently had a trespassing at the same location, August 30th.
All right, thank you for that information. Mr. Guerrero, sir, is this your signature here at the bottom of this plea form?
Who's talking? The judge?
Can you hear me, Mr. Guerrero?
Yes, ma'am.
Sir, is this your signature at the bottom of this plea form?
Oh, yes.
Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication at this time?
No.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
All right, there is a sufficient factual basis in your case. You are alert, you are intelligent, you are adjudicated guilty, ordered to serve 5 days in jail with credit for 2 days' time served. You're ordered to not return to 4704 South Orange Blossom Trail. Further, you must pay mandatory court costs within 365 days of your release. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Todd Deshay Newton. Mr. Newton, the court finds probable cause for count 1, driving while your license was revoked as a habitual offender. Bond stays at $2,500. Count 2, resisting an officer without violence. Bond stays at $100. Count 3, possession of cannabis. Bond stays at $100. And the court was unable to find probable cause as to the petty theft charge. Ms. Fleming, do you have any motion as to that charge?
No, Your Honor.
All right, the court does not find probable cause for count 4 petty theft. Your ROR, that's to that count. I have appointed the public defender to represent you, sir. The court is ordering that you have possessed no unlawful substances and consume no unlawful substances as a condition of your release, and that you not drive a motor vehicle as a condition of your release. Thank you, sir. Juanita Johnson.
Yes.
The court finds probable cause for battery. Bond stays at $500. You're ordered to have no contact with the victim, to not return to the location where this incident occurred, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you.
Your Honor, I don't know, I believe she needs a one-time return with law enforcement. I thought they were living together.
I'll allow a time return with law enforcement to recover any personal items or effects. Thank you. Bobby Brandon Lee,
Bonded.
previously bonded per the jail staff. Jadarius Quayne McMillan. Sir, you're charged with loitering and prowling. The court finds probable cause for that charge. Bond stays at $250. Thank you, sir.
Your Honor, state we just asked for a no return.
All right, sir, the court is ordering you to not return to the location where this incident occurred. Thank you. Timothy Temples. The court finds probable cause for loitering and prowling, that's count 1. Bond stays at $250, and trespassing in a structure or conveyance, count 2. Bond stays at $100. The court is further ordering you to have no contact with the victim and not return to the location where this incident occurred.
Your Honor, the
ma'am.
offer from the state was an adjudication of guilt, credit time served, no return to 13999 West Colonial Drive and court costs. Mr. Temple would like to accept and enter plea of no contest.
All right, that's fine. How much time served does he have?
2 days.
Okay. Mr. Temple, is this your signature here at the bottom of this plea form, sir? Did you read the plea form in its entirety before you signed it? Are you under the influence of any alcohol, drugs, or medication at this time? Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
Sir, there's a sufficient factual basis to accept your plea. You're alert, you're intelligent, you're adjudicated guilty as to both count 1 and count 2, and work to serve 2 days in jail as to both counts with credit for time served as to both counts concurrent. Further, the court is ordering you to not return to 13999 West Colonial Drive, and you are ordered to pay mandatory court costs within 365 days of your release from incarceration. Do you have any questions?
No, ma'am. Thank
You
you.
have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit. Kimberly Wilsinski. Ms. Wilsinski,
Actually said it right.
well, sometimes I get it right. You have a case for failure to appear, for which bond will stay set at $500. You also have cases of battery, and there are 3 of them, and they all 3 have the exact same probable cause, so I'm trying to figure out why there are 3. There's only 1 victim that I saw in all 3 of them.
Yeah, I believe the victim being Michael Johnson.
The probable cause affidavit is identical in all 3 cases. It does not identify multiple victims. It only identifies 1 victim.
That's fine, Your Honor. State we just asked for bond on 1 and ROR on the other 2.
The court finds probable cause as to case number 2022 MM 433 AA. And bond will stay set at $500. The court is RORing you and finding no probable cause as to 2022 MM 434 AA and ordering an ROR and finding no probable cause as to 22 MM 435 AA.
Your Honor,
Yes, ma'am.
as to the failure to appear and the out on bond 2022 MM 313 AA, there is an offer from the state to resolve both. They're both trespasses. And 2022 MM 313 AA, it's an adjudication of guilt.
Oh, hold on a minute. You're talking too fast.
I'm sorry, Your
I
Honor.
mean, first of all, I need a case number for everything.
Yes, Your Honor, and
Okay,
20.
Start with first identifying the case by charge.
Okay. In the out on bond, the trespass in a structure or conveyance, an occupied trespass in a structure or conveyance, the offer from, in 2022, sorry, MM 313 AA.
Okay, stop right there. 2022 MM 313 AA. Okay. 313. So I don't have I don't have a factual basis for that. Are you going to stipulate to a factual basis?
Yes, Your
Okay, all right, and then on the next one,
Honor. And
just by case number, please.
yes, Your Honor, 2022 MM 343 AA. The offer is an adjudication,
Okay, wait, I don't have a factual basis on that one either.
and defense will stipulate to a factual.
Okay, now you may proceed. Thank you.
And the offer is an adjudication of guilt, credit time served, no return to 370 East Main Street, court cost, and there's a cost of investigation.
And cost investigation of $179.25 to Apopka Police Department.
Please include that on the form, and there should be 2 plea forms, right?
I placed both.
No, ma'am.
You want to? Okay.
Yes, ma'am.
I will do that right now.
She's trying to plea out 313 AA and 343 AA.
Taylor, can you give me that amount one more time?
$179.25, Apopka.
Why is the no return to the same location on both cases?
They are the same location, Your Honor.
They were the same location?
Yes, 370 East Main, which is discount beverage.
Okay. And what is the time served on the 313 case? 22 MM 313?
Including today, it'll be 6 days.
6 days, Your Honor.
And what is the time served on the 22 MM 343 case?
21 days.
And defense, you are stipulating to a factual basis as to both these cases?
Yes, Your Honor.
All right, Ms. Wilzinski, ma'am, is this your signature at the bottom of these two plea forms?
Yes, ma'am.
Did you read these plea forms before you signed them?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine at this time? Do you understand that a conviction on these cases will subject you to being deported if you are not a U.S. citizen?
Yes, ma'am.
All right, based on stipulation of counsel, I find there is a sufficient factual basis, and I find you are alert, you're intelligent. As to 2022 MM 313AA, you're adjudicated guilty. You're sentenced to serve 6 days in jail with credit for 6 days time served. You're ordered to not return to 370 East Main Street. Further, is that in the city of Orlando or some other city?
It's a Apopka, Your Honor.
In Apopka, Florida. Further, you must pay mandatory court costs. I am ordering your release as to this charge. Court costs must be paid within 365 days of your release. As to 2022 MM 343AA, you are adjudicated guilty, ordered to serve 21 days in jail with credit for 21 days time served. You're ordered to not return to 370 East Main Street, again in Apopka, Florida. And you must pay costs of investigation of $179.25 to the Apopka Police Department. All monies must be paid within 365 days of your release. I am ordering your release as to this charge as well. Do you have any questions, ma'am?
No, ma'am.
Hold on a second. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. So, Madam Clerk, don't let her go yet. Did I already enter the order on the 433, 434, 435?
Yes, ma'am.
Okay. 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 All right, thank you, ma'am. My pleasure. Matthew Montag. Sir, you're charged with being in a park or a facility after closing hours. The court finds probable cause, bond stays at $250.
The offer from the state, Your Honor, is an adjudication of guilt, credit time served. No return to 2177 South Summerlin Avenue, and court costs. Mr. Montag would like to accept an answer plea of no contest.
All right, Mr. Montag, sir, is this your signature here at the bottom of this plea form being handed to me? Yes or no? Yes. Did you read the plea form in its entirety before you signed it? Yes or no? Yes. Are you under the influence of any alcohol or drugs or medicine today?
No.
Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen?
Yeah.
Sir, there is a sufficient factual basis in your case, and you are alert, you are intelligent, you are adjudicated guilty. Time served?
Yeah.
2 days.
Yes.
Time served?
Yes.
2 days.
Yes, Judge.
You're ordered to serve 2 days in jail with credit for 2 days' time served. You are also ordered to not return to 2177 South, looks like Summerline. Is that it, Summerline, or should it be Summerlin?
Summerlin, Your Honor.
Summerlin Avenue, Orlando, Florida.
Yes.
Further, the court is ordering you to pay mandatory court costs. Court costs must be paid within 365 days of your release, and I am ordering your release as to this charge. Do you have any questions?
No.
Yes or no?
No. Is there, no.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Shaquanda Rashal Davis. Ms. Davis, you were picked up for failure to appear on a driving with license without knowledge, and A failure to appear on another driving with license without knowledge. For the first case, bond stays at 2,000, and the second case, bond stays at 750.
And Your Honor, there was an offer to resolve both cases. In 2021 C.
Wait, will resolving these cases put her in the position of becoming a habitual traffic offender?
No, Your Honor.
Not that I noticed.
Because if she gets 3 convictions within 5 years, then she becomes H2O.
Yes, Your Honor. She will only have 2.
Well, most people will get 2, get 3. Do you think it's wise for her to do this today, or maybe consult more in depth with the lawyer before doing it today?
The lawyer that's assigned to the case actually put notes in that he would want to resolve the case, Your Honor, which is why I was resolving both cases today.
All right, as long as she's aware, it's fine. That's fine. I'll take the offer.
And in 2021 CT 1016 AE, the offer is a withhold of adjudication, credit time served, and court costs. And in 2022 CT 669 AO, the offer is an adjudication and credit time served.
And court costs.
And court costs, Your Honor. And she would
And
like,
you have a plea form for both?
yes, Your Honor. And Ms. Davis would like to accept and enter a plea of no contest as to both charges.
Okay, and will you be stipulating that there's a factual basis on both?
Yes, Your Honor.
Okay. What is the time served on the 669 case?
25 days,
And what is the time served on the 1016 case?
13 days.
Thank you. Ms. Davis, ma'am, is this your signature at the bottom of these 2 plea forms?
Yes, ma'am.
Did you read these plea forms in their entirety before you signed them?
Somewhat.
Here you go, so you can read them all the way.
I have one, Your Honor.
Nope,
I put both on the same.
she can read this one.
Okay.
Ms. George, when there are multiple cases, please do multiple plea forms. Ma'am, I want you to read the plea form. I don't want you to just hand it back to me. Just read it. Is there anything else you need to sign while she's doing her reading? So I'm good. Where's her stuff? Did I hand it to you? Oh, I still have it. That's Ms. Davis. Okay. I'll keep it till we're done. Leo Gradley.
Behavior, Your Honor.
Defense will waive, Your Honor.
All right, court finds probable cause for driving on a suspended license. Bond stays at $500. The court is ordering the defendant to not drive without a valid driver's license. Public defender is appointed. Jonathan Alexis Martinez Gonzalez. Bonded per the jail staff. Mina Balsworth. Ms. Balsworth. The court finds probable cause in your case for possession of cocaine. Bond stays at $1,000.
And Ms. Davis is ready, Your Honor.
All right, recalling Ms. Davis. Ms. Davis, your attorney tells me that you wish to enter a plea of no contest. Is that correct?
Yes,
As to both cases, ma'am?
yes,
And are these your signatures at the bottom of these plea forms?
yes, ma'am.
Have you now had an opportunity to read the plea forms?
Yes, ma'am.
Do you have any questions about anything contained on these documents?
No, ma'am.
Are you under the influence of any alcohol or drugs or medicine at this time?
No, ma'am.
Do you understand that conviction on these cases will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
And counsel, I believe you have stipulated to a factual basis, is that correct?
Yes, Your Honor.
All right, counsel is stipulated to a factual basis as to both cases, and therefore I find there is a sufficient factual basis to accept your plea. I find that you are alert and you are intelligent. As to case number 2021 CT 1016 AE, the court withholds adjudication of guilt and orders 13 days in jail with credit for 13 days time served, and orders you to pay mandatory court costs. With regard to case number 2022 CT 669 AO, the court adjudicates you guilty and orders 25 days in jail with credit for 25 days time served, and orders mandatory court costs. All court costs on both cases must be paid within 365 days of your release. I am ordering your release as to these cases. Do you have any questions?
No, ma'am.
You have the right to appeal the sentences. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, ma'am. You may exit. Krista Davis. You're charged with grand theft, third degree of a motor vehicle, for which the court does find probable cause, and bond stays at $1,000, and possession of 3,4-methylene methamphetamine, MDMA, ecstasy, bond stays at $150. The court is ordering you to have no contact with the victim, not return to the location where this incident occurred, and consume or possess no illegal substances as a condition of your bond. Thank you, ma'am. Anthony Day.
Your Honor, he qualifies for pretrial.
He what? Qualifies? Oh, he does. All right, Mr. Day, the court finds probable cause for grand theft, third degree of a motor vehicle, and I will order you to be released on the pretrial release program. You are ordered to comply with all the conditions of pretrial release. Further, you are ordered to not return to the location where this incident occurred, and you are also ordered to have no contact with the victim. Thank you. Sammy Fernandez. You were picked up, is that Sammy Fernandez?
Yes, Your Honor.
Oh, I'm sorry.
He stated he already posted the bond.
Oh, did he?
Yes, so I would just ask that you stay the bond, Your Honor.
All right. Did you already post the bond, sir?
You're not seeing it?
Yes, man, they went this morning at like 9
Oh,
o'clock.
can I have that?
We don't have the bond in our system as of yet.
Fernandez.
Yep, he said he's positive.
No, this day.
Okay.
The one you just ordered pretrial.
So as to Anthony Day, you don't show the bond in being posted in the system?
No.
Does it, I mean, is it simultaneous? Like when someone pays the bond, does it automatically upload?
We put a bond pending alert so we know that the bond needs to be processed, but nothing has been.
I'm just gonna stay the bond. That's what he's asking for, so I'm gonna grant that. The bond is stayed at $1,000, and the court is vacating the order to release the defendant pretrial release. However, the conditions all remain the same. Sammy Fernandez. Mr. Fernandez, you were picked up for failure to appear on 2 counts, battery on a Leo and resisting an officer with violence, and bond will stay set at no bond on both count 1 and count 2. Thank you, sir. Johannes Gonzalez Murphy. Mr. Johannes Gonzalez Murphy, the court finds probable cause for count 1, possession of a firearm by a convicted felon. Bond stays at $4,000. Count 2, possession of fentanyl. Bond stays at $150. Count 3, possession of methamphetamine. Bond stays at $150. Count 4, possession of cannabis less than 20 grams. Bond stays at $100. And count 5, possession of drug paraphernalia. Bond stays at $100. The court further revokes the bond on the out on bond case and sets bond at no bond on all counts. Jonathan Hayes. Unbonded per the jail staff. Jaleesa Haynes.
Your Honor, she qualifies for pretrial.
All right, Ms. Haynes, the court finds probable cause in your case for battery on a law enforcement officer, and I order you to be released in the pretrial release program. You must comply with all the conditions of pretrial release.
Any conditions?
No, other than to follow your requirements. Mariah Jarrell.
Refused, Your Honor?
Defense will waive, Your Honor.
Okay, the defendant was picked up on a probable cause warrant for count 1 burglary of a dwelling. Bond stays at $7,500. Count 2 grand theft. Bond stays at $1,500. The conditions are no return, possess no weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Jack Charles Keenan. The court finds probable cause in your case for count 1, possession of 3,4-methyl MDMA ecstasy with intent to sell or deliver. Bond stays set at $1,500. Count 2, possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays at $150. Count 4, possession of methamphetamine. Bond stays at $150. Count 4, possession of cannabis less than 20 grams. Bond stays at $100. And count 5, possession of drug paraphernalia. Bond stays at $100. You're ordered to possess no weapons, no firearms, and actually, I'm sorry, that's not an order. You're ordered to consume and possess no unlawful substances as a condition of bond. The court also finds probable cause in your second case for possession of a suspended driver's license. Bond stays at $500, and you're ordered to not drive without a valid driver's license. Thank you, sir. Raymond Lewis.
Behavior, Your Honor?
Do you wish to waive his presence?
Yes, Your Honor.
All right, the court does find probable cause for criminal mischief for greater than less than or equal to $1,000. Bond stays set at $1,000. Defendant is ordered to not return to the location where this incident occurred and have no contact with the victim. Miguel Martinez Marrero.
He refused?
Defense waives, Your Honor.
Defense is waiving. Defendant was picked up for failure to appear. Bond will stay set at no bond on both count 1 and count 2. John Wayne Murray.
Bonded?
Bonded per the jail staff. Billy Neal. Mr. Neal, you're picked up for possession of 3,4-methylene methamphetamine MDMA ecstasy, for which the court finds probable cause. Bond stays set at $1,000. The court is revoking bond on both your out on bond cases and setting bond at no bond. Everton Pommels. Mr. Pommels.
Yes, Your
All
Honor.
right, sir. You were picked up on a probable cause warrant for count 1, possession of cannabis. Bond stays at $1,000. Count 2, and it's greater than 20 grams. Count 2, possession of cocaine. Bond stays at $7,500. Count 3, possession of controlled substance with intent to sell. Bond stays at $1,000. And count 4, resisting an officer without violence. Bond stays at $100. I can't even read my own handwriting. What did I? Conditions are that you do not possess any firearms or weapons and do not consume or possess any illegal substances. Thank you, sir. The court takes no action on well, I only have one. The one for no valid, 22 CF 98808. No action on that one. Is there another one? Oh, okay. So all I have is a no valid, no action on that. William Richardson. Sir, the court finds probable cause in your case for you, which you were picked up trafficking and 10 grams or greater of 3,4-methylene methamphetamine MDMA with a weapon, and bond stays set at no bond. Possession of firearm by a convicted felon, bond is set at $150. Possession of ammunition by a convicted felon, bond is set at $150. Court is ordering you to possess no firearms or weapons as a condition of release. Surrender any firearms or weapons to law enforcement within 24 hours of release. Further, the court finds probable cause for grand theft, second degree, of $20,000 or more. Bond stays at $2,500, and count 2, criminal mischief, greater than or equal to $1,000. Bond stays at $150. You're ordered to not return to the locations where these incidents occurred and have no contact with the victims.
Your Honor, on count 1 of the 22 CF 11744, I do believe that Mr. Richardson is entitled to a bond.
Yes, then I'll set bond at $100,000.
Thank you.
As to count 1, bond is set at $100,000 in that case. Jaquez Hemion Rowe. Is that who you are? Are you Rowe? Are you Rowe, Mr. Rowe? Okay. Mr. Rowe, the court finds probable cause in your case for possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays at $1,000, and possession of cannabis less than 20 grams. Bond stays at $100. You're ordered to consume or possess no illegal substances as a condition of that bond. The court finds probable cause for having an open container. Bond stays set at $250 in your second case. Thank you, sir. Jacob Rear Leonard Schumerborn. The court finds probable cause for dealing in or trafficking in stolen property. Count 1, bond stays at $2,500, and count 2, grand theft of a motor vehicle, bond stays at $5,000. As to both counts, the court is ordering you to have no contact with the victim and not return to the location where this incident occurred. Ryan James Seaman. Mr. Seaman, the court finds probable cause for count 1, possession of methamphetamine, bond stays at $1,000, and count 2, fraudulently impersonating or intentionally or unlawfully using or possessing identification of another, bond stays at $500. You're ordered to have no contact with the victim, consume or possess no illegal substances as a condition of release. Michael David Spiegel. Michael David Spiegel. The court finds probable cause for possession of methamphetamine, for which bond shall stay set at $1,000. You're ordered to consume or possess no illegal substances as a condition of release. Thank you, sir. Melvin Thompson. The court finds probable cause in your case for grand theft of a motor vehicle. Bond stays at $3,500. The court also finds probable cause in your second case for possession of cannabis, and bond stays at $250. You have an out on bond case for which the court revokes bond and our order a new bond as to count 1 of $2,000, as to count 2 of $2,000.
Excuse me, Your Honor. There is no action on count
Oh, there's no information on count, which one?
2 and 3.
2 and 3, okay, so no action as to count 2 and no action as to count 3. $2,000 as to count 1. Thank you. Shaitel Lee Thompson. Refused. What says the defense as to Chantel Thompson, who refused?
Waive, Your Honor.
All right, his presence is waived, and the court does find probable cause as to count 1. Bond stays at 1,000, and as to count 2, bond stays at 500. The defendant is not to return to the location where this incident occurred. Jose Manuel Torres Vega. Oh, I was thinking Rose. All right, bonded per the jail staff. That's the last one I have. Why do I have all these? Well, but did I mean, I can go ahead and address. Is there a case number on them? No. Yeah, there's some case numbers on them. Let me see here. No, as to Bobby Lee and Jorquez Rowe and Ryan Seaman and Jose Torres Vega, they do not qualify for the public defender. So the public defender was not appointed in these 4 cases. Not a public defender. I was looking for them and I didn't see them. All right, what else do we have? Anything else? All right, court will stand in recess. Sir, the court finds probable cause for the charge of burglary or of a dwelling with an assault or battery with a firearm, and bond will be set or stay set at no bond. And the court finds probable cause for count 2 criminal mischief. Bond will stay set at $250. As conditions of release, you are ordered to have no contact with the victims, not return to the location where this incident occurred, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Melissa Billman.
Medical, Your Honor.
Does the public defender wish to waive her presence? All right, the court does find probable cause as to count 1. Bond is set at 1,000, and as to count 2, bond is set at 150. The defendant is ordered to have no contact with the victim and not return to the location where the incident occurred. Ray Jean Blair.
He was a refusal.
Defense will waive, Your Honor.
All right, defense is waiving his appearance. The court finds probable cause as to count 1. Bond is set at no bond, or stays at no bond. Count 2, bond is set at $2,500, and count 3, bond is set at $150. The court is ordering the defendant to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release, no return and no contact.
I believe he also has another case. Your Honor.
Yes, and as to the second case, possession of fentanyl, the court finds probable cause for count 1. Bond stays at 1,000, and count 2, bond stays at 150. Same conditions as to both cases. Eric Buckner. Are you Eric Buckner? All right. In your case, the court finds probable cause for burglary of a structure. Bond is set at 3,000. Okay, bond is set at 3,000. Is this just to show me he did it? Okay, $3,000. As to 3,500, sorry, stays at 3,500. As to count 2, bond stays at 500. As to count 3, bond stays at 500. As to count 4, bond stays at 100. The court is appointing the public defender to represent you. Its condition of bond is no contact with the victims and no return to the location where this incident occurred, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Thank you, sir. Hakeem Holloway. Mr. Holloway, in your case, the court finds probable cause for count one, tampering.
Your Honor, he's stating he does not know what he was charged with.
Oh, let me have that back.
Hold on.
No, he can stay. Mr. Buckner, I didn't say the charge. Count one is burglary of a structure. Count two is grand theft third degree. Count four is criminal mischief. Count five is resisting an officer without violence. Actually, I numbered that wrong. Count two is grand theft, three is criminal mischief, and four is resisting an officer without violence. The bonds are $3,500 on count one, $500 on count two, $500 on count three, and $100 on count four. Does that answer your questions now? All right, thank you. Okay, Mr. Holloway? All right, sir, the court finds probable cause as to count one, tampering with physical evidence. Bond stays at 1,000. Count two, resisting an officer without violence. Bond stays at 100. And count three, possession of cannabis. Bond stays at 100. Further, sir, you have a charge of failing to appear. Bond will stay at no bond on that case. As a condition of your bond, the court is ordering no further sanctions, sir. Thank you. Devontae Taquan Hunter. Mr. Hunter, in your cases, the court finds probable cause for driving with a suspended license while your license was already suspended, and bond stays at 500. The court revokes bond on your other two cases of driving on a suspended license and sets bond at no bond on both cases. Further, sir, the court finds probable cause for your second case, resisting an officer without violence. Bond is staying at $500, and a state misdemeanor bond is, the court's gonna find probable cause and release you on your recognizance as to that second count. Thank you, sir. Golding Ernest Robert.
Behavior?
Defense will waive, Your Honor.
All right, defense is waiving. Court finds probable cause for disorderly conduct. Bond stays at $150. No further sanctions. Corey Trammell.
Refusal?
Defense will waive, Your Honor.
Defense is waiving. The court finds probable cause for the new law, possession of cannabis. Bond stays at 1,000. Count two, possession of, well, count one is possession with intent to sell or deliver. Count two, possession of cannabis. Bond stays at 150. And count three, possession of paraphernalia. The court will order and release on recognizance. As to the on-view violation of probation, bond will stay set at no bond.
He's also out on bond.
No action on out on bond. Keaton Walton.
Refusal?
Defense will waive, Your Honor.
Okay. As to the charge, violation of domestic injunction, bond will be set at $2,500. No contact with the victim whatsoever. No return to the victim's household. No possession of weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Revoking the bond on the out on bond case, bond will be set at no bond on the out on bond case. Jean Carlos Maynard Melendez.
Also refusal?
Defense will waive, Your Honor.
All right, as to the sole count of battery, the court finds probable cause, felony battery, and bond is set at $2,500. No contact with the victim, no return, one visit in the presence of law enforcement if appropriate, no possession of weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. revoking bond on the out on bond case and setting a new bond of $2,500. Tamika Anglin, in your case, the court finds probable cause for battery, and there's a witness. Raise your right hand to be sworn in.
Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State your name for the record.
Daryl Anglin.
And Mr. Engler, either the state or defense or both may have questions of you. Please speak clearly into the microphone when the questions are asked.
No problem.
Good morning, sir. Can you please state your relationship to Miss England?
Husband.
Are you afraid of her?
No, sir. No, ma'am. I'm sorry.
Has anything like this ever happened before?
Yeah, not to this severity, though. No. Okay.
Has there been a physical incident between the two of you before?
No, ma'am.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes, ma'am.
And do you want to have contact with her?
Yes.
And she qualifies for a program called pretrial release, meaning she could get out of jail without paying money to get out, but she'd be supervised by someone here at the jail. Does that sound okay to you, or is that something you would object to?
Explain that to me again.
It is a program that's run here at the jail, so she'd be able to get out of custody without paying any money.
Okay.
But whatever conditions that the judge sets, they'll just check in to make sure that she was completing those conditions.
Okay.
But she'd be able to get out with no money.
All right.
Is that something that sounds okay to you?
Yes, ma'am.
All right. She has no further questions, Your Honor, and has no objection to PTR.
All right, does she qualify for PTR?
Yes, she qualifies.
All right, the court will find probable cause for the charge, and I'll order you release PTR and to comply with all the conditions of PTR, including the court is ordering you to possess no weapons or firearms and surrender them to any in your possession to law enforcement within 24 hours of your release, and have no hostile contact with the victim. Thank you. Thank you, sir. Tuesday, Bellamy. Ms. Bellamy, the court finds probable cause in your case for battery, domestic violence, and bond is,
Your Honor, she qualifies for
the
pretrial.
court will order you to be released in the pretrial release program and order no contact with the victim, no return, with the exception of a one-time visit with law enforcement to obtain personal belongings and effects, and possess no weapons, no firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of release. Thank you, ma'am. Tatiara Brown,
And Your Honor, she qualifies for pretrial as well.
thank you. Ms. Brown? Ma'am, the court finds probable cause in your case for battery, domestic violence. We have a witness, sir. Raise your right hand to be sworn in.
Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Swear.
State your name for the record.
Kamar Brown.
Thank you, Mr. Brown.
Good morning, Mr. Brown. Can you please state your relationship to Miss Brown?
Husband.
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you want to have contact with her while this case is pending?
Yes.
And she, I believe, also qualifies for pretrial release,
Can I make a statement?
of course.
I don't believe I'm a victim in this case. I keep telling the officers yesterday that this is not a situation of domestic violence to me.
May I interrupt, sir?
Yeah.
Listen, this is not the forum.
Yeah.
There is a forum. There will be an opportunity for you to inform the appropriate prosecutor if you want to decline prosecution. I'm simply determining probable cause at this hearing. Now, she does qualify for pretrial release, so I will be releasing her pretrial release. But I can't make any rulings on whether or not she's guilty or
Yeah,
not
I just want
guilty.
to stay firm. The same thing I told the cops
Sir,
today as well.
sir.
Yeah, that's all.
Do you understand me when I tell you this is not the time or the place to try the case?
Okay, no problem.
All right, but there is a time and a place where you can decline to prosecute. It's not right now in this forum,
Okay.
okay?
All right.
I'm also giving you a card, and you can call and tell them.
Okay, thank you.
All right, the court does find probable cause. I'm going to release you in a pretrial release program. You are ordered to comply with all conditions of pretrial release. Additionally, you are to have no hostile contact with the victim. You are to surrender any weapons or firearms in your possession to law enforcement within 24 hours of release and possess no weapons or firearms as a condition of your release. Thank you, ma'am. Stephen Kuhn. Mr. Kuhn, the court finds probable cause in your case for battery, domestic
As well.
violence. He qualifies?
Yes, sir.
And sir, you do qualify for pretrial release, so I'm ordering you to be released in the pretrial release program. Further, sir, I am ordering you to have no contact with the victim, not return to the location where this incident occurred, with the exception of a one-time visit with law enforcement to recover personal belongings and effects. You are ordered to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Walter Gerardo. Walter Gerardo. All right, sir, in your case, the court finds probable cause for 3 counts. Count 1 is battery. Bond is set at $500. Count 2, battery. Bond is set at $500. And count 3, resisting an officer without violence. Bond is set at $500. In each count, sir, the court is ordering you to have no contact with the victim and not return to the location, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Jamar Jarvis. Sir, in your case, the court finds probable cause for violation of a domestic injunction, and bond is set at $2,500, and probable cause for count 2, violation of a domestic injunction, and bond is set at $2,500. The court is ordering a revocation of your bond on your other case and sets a new bond as follows. Count 1, $2,000. Count 2, $150. Count 3, $100. As a condition of bond, you are ordered to have no contact with the victim, not return to the location where this incident occurred, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir.
Excuse me, I can't afford all this.
Unfortunately, sir, this is the bond that I am imposing. You can consult with your attorney regarding filing a motion in the future to reduce your bond.
All right, thank you.
Amanda Murphy. Ms. Murphy, the court finds probable cause in your case for battery, domestic violence, and I think there's a witness. We will swear the witness in.
Your Honor, she qualifies for pretrial.
Okay, thank you.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record.
Sean Massey?
Good morning, Mr. Massey. Can you please state your relationship to Ms. Murphy?
Fiance?
Are you afraid of her?
No,
Has anything like this ever happened before?
not this severe.
Has a physical incident ever happened between the two of you?
No,
Do you want to have contact with her while this case is pending?
no,
And if anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
yes.
Your Honor, I also believe DCF was contacted, so they would ask that that be a condition. The state has no further questions.
All right, any questions?
Yes, Your Honor. Do you still reside at the home, the family home?
Actually, I was gonna let her go back there because she also has 3 other children, and I'm gonna be going out. But I do have to go back there and grab some of my belongings.
Oh, so Your Honor, I would ask that you allow her to go back to the home in this case.
All right, sir, do you understand that I'm going to order her to, I'm going to allow her to go back to the home and order her and you to maintain separate residences? So that means that you just testified that you're going to let her stay there?
Yes,
Is
ma'am.
that correct? Okay. All right. Ma'am, I am ordering you to be released on the pretrial release program. You're ordered to have no contact with the victim in this case. DCF was involved because the baby was was, could have been injured during this altercation. And so you are ordered to comply with any DCF order or plan. You are to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. I'm ordering, what maintaining separate residence means, ma'am, is that you cannot live with him and he cannot live with you. If he chooses to vacate, then you can stay there. If he changes his mind about vacating, then you cannot be there. Do you understand? All right, do you understand that as well, sir?
Yes, ma'am.
And any other conditions state?
No, Your Honor.
Did I do the weapons or firearms? All right, thank you, ma'am. Michael Thomas,
Defense
he's a
will-
refusal, okay. Defense is waiving his presence. The court does find probable cause for battery, domestic violence, and sets a bond of $500. Order no contact, no return. One-time visit with law enforcement to recover personal effects. Surrender any weapons or firearms and possess no weapons or firearms within 24 hours to
Your Honor,
surrender.
state would bring to your attention, he is on active probation also for a BAT DV. He was just placed on that probation about 20 days ago,
Okay,
and has multiple prior BAT DVs with the same victim.
with the same victim? Wow. He was actually placed on probation on that case?
He is on active probation for a BAT DV.
Okay, so it'll be in the same division with the same judge. Okay, thank you. Alexander Thomaso,
Defense will waive, Your Honor.
the court finds probable cause for count 1, violation of a domestic injunction, sets a bond of $2,500, and count 2, resisting an officer, bond stays at $500. The court is revoking the bond on the out on bond case and setting a bond of no bond on both counts. Further, the court is ordering no contact with the victim, no return, possess no weapons, no firearms, and surrender any weapons or firearms within 24 hours to law enforcement, 24 hours of release. Robert Wilborn, sir, the court finds probable cause in your case for battery,
Your Honor,
dating.
qualifies for pretrial.
Thank you. Battery, dating, violence, and you do qualify for the pretrial release program, so I'm ordering you to be released pretrial. The court is ordering you to comply with all the conditions of pretrial release. Further, you must have no contact with the victim, not return to the location where this incident occurred, maintain a separate residence from the victim. Further, you must surrender any weapons or firearms to law enforcement within 24 hours of release and possess no weapons or firearms as a condition of your release. Thank you, sir. Miguel Gomez? Okay, Mr. Gomez, you were picked up on an out-of-county warrant from Brevard County, and bond will stay set at no bond on that case. You understand, sir? Thank you. What seems to be the delay?
Just signing the no contact, Your Honor.
Oh, okay. Thank you. Inocencio Gonzalez Ocasio. Mr. Ocasio, the court finds, actually, you were picked up from Osceola County warrant, and bond stays set at $250. Thank you, sir. Luis Angel Perez Rodriguez. Sir, you were picked up on an out-of-county warrant, appears to be from Lake County, and bond will stay set at $2,000. It's for a failure to appear. Thank you, sir. Kelsey Lamont Boyce.
Defense will waive, Your Honor.
Defense is waiving. The court does find probable cause on the new case. And it sets a bond on count 1 at $5,000, or it stays at $5,000. Count 2, bond stays at $150. Count 3, bond stays at $100. The court's ordering possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release, no contact and no return. And as to the on-view violation of probation, bond stays set at no bond. Jerry Kemp.
Was it refusal?
Defense will waive, Your Honor.
All right, Mr. Kemp is refused and defense is waiving his presence, and the court, bond will stay set at no bond on the violation of probation. That concludes the morning docket unless we have any other
I believe
hearings.
Mr. Kemp has two
We have
cases.
two? Okay,
He also has a failure to
all
appear.
right, several. Oh, way more than two. State, as to State versus Calvin Bernard Wells. Do I need to call the case numbers on all these? Do you have them, State? Yes, ma'am.
Oh, Your Honor, I was talking about the second case for Mr. Warren.
There was a failure to appear, Your Honor, on the prior case.
Let me see that. Did I not address a failure to appear? Did I have a failure to appear?
I believe it was just the BOP.
I addressed the violation of probation,
Yes, Your Honor.
and I addressed the new, I did not address the failure to appear. So yes, there is a failure to appear, and bond will stay set at $500 as to the failure to appear. This is as to Mr. Warren, Jerry Warren. All right, now I got everything. Here you go. All right, State, do you have these cases?
Yes, Your Honor.
All right, then,
To preserve your voice, if you want to just say the name or the case number, and I can say the other, up to you.
Calvin Bernard Wells, any objection?
Denied and information was filed.
That's denied per the state and information was filed. Do I have the date, Madam Clerk? What's today's date? All right, thank you. I'll just go ahead and date them all. Susan Richardson,
Denied and information was filed.
First State, information is filed. Motion is denied. Venus Lot,
Granted, notice of non-filing.
all right, granted. Rachel Ellen Lancaster,
Denied and information was filed.
it's denied. Clifton Tyrone DeAndre Jackson,
Granted, notice of non-filing.
thank you, it's granted per the state, notice of non-filing. And John Anthony Haywood,
Denied and information was filed.
okay, denied. Matthew Antonio Glover,
Denied and information was filed.
that is denied. Lonnie J. Bremett,
Denied and information was filed.
all right, that's denied. Maurice Linnell Bell,
Granted, notice of non-filing.
granted per the state, notice of non-filing. And Lonnie J. Bremett,
Granted, it was no build.
no bill per the state.
Your Honor, Mr. Brummett has two.
Yes, ma'am.
The 22 CF 10457 should have been denied. The 22 MM 6141 should be granted.
So the 22 MM 6141 AO is granted.
Granted, yes. The previous 10457.
The 20, no, Bremett. 22 CF 10457 AO is denied.
Yes.
Roderick Jamal Baker,
Granted, notice of non-filing.
that is granted. Thank you, State. Why is Judge McGinnis's name on all these orders? These are printed by the clerk. These no contact orders that y'all just gave me? Oh, you didn't do them this morning? Oh. Well, are these for cases today? Then why is his name on them? There are a lot of them, and some of them have no name, and then some of them have his name. Let's see here. We'll stand in recess.
Okay.
Hello.
All right, good morning, sir. State your name, please.
Thomas Edward McGee.
All right, Mr. McGee, we reset this from yesterday regarding, there was a period we'd only gotten one of the 2 pages of the charging affidavit. Court has received the second page. Did the defense receive that copy?
Yes, Your Honor, and the only probable cause argument that I would still make from yesterday would be the lack of PC for the alter or destroy evidence, as I believe nothing was recovered or searched for in the area that he may have thrown something.
All right, State, do you wish to respond to that?
There will be no objection to an ROR on that charge if the court agrees with the defense's argument.
Okay. I agree with the defense on that. So, Mr. McGee, we've got a total of 6 counts. The first 3 are possession of a controlled substance without a prescription. The bonds on each of those is $2,500. Count 4, I'm going to ROR you on that. Count 5, paraphernalia is $500, and the resisting an officer is $250. Public defender's been appointed. He's currently out on pretrial release. 22 CF 2026. State, what's the status of that case?
2026. Just one second.
Yeah.
Your Honor, he's still currently out on direct PTR in that case.
Okay. And has that case been filed on? I don't have any other information about it.
1 second. No, Your Honor, at this time it hasn't been. He doesn't even have an arraignment date.
Okay. All right, so the state hasn't made a filing decision on that. I'll just take no action on that.
Thank you, Your Honor.
Okay.
Thank you, PTR.
All right. Thank you. Good luck, Mr. McGee. I've got Michael Beaulieu.
He is present and approaching, Your Honor. Defense would have a probable cause argument to one of the listed charges.
All right. Good morning, sir. State your name, please.
Michael Boyer.
Sir, you're here for initial appearance. You've been arrested for, it's like altering, destroying, concealing, removing physical evidence. And Yeah, I can't quite even understand what this means.
Yeah, me neither, sir.
Yes, Your Honor, if I may.
Yes, go ahead.
I pulled up the statute before we started today. This is charged under, obviously, Florida Statute 777.04 subsection 3, which in specific states a person is guilty of an attempt, solicitation, or conspiracy who agrees, conspires, combines, or confederates with another person or persons to commit any offense, commits the offense of criminal conspiracy. I find no indications from this arrest affidavit that any third party was involved at all or any conspiracy was talked about or attempted. As such, I would argue there is no probable cause for the charge as listed, Your Honor, and request ROR.
No probable cause for any of that.
Okay. State, do you wish to respond?
Yes, Your Honor. The affidavit states that, oh gosh, this name, Castellucci's supplemental report was part of the decision-making process in filing this charge. This affidavit does not contain the necessary probable cause, so we would be asking for 24 hours to supplement the report, but the state agrees that there is no probable cause for this charge in this affidavit as written.
Okay.
Your Honor, if I may.
Go ahead.
I would like to just lay an objection to the state's request to 24 hours if the court is amenable.
I'm happy to hear whatever you have to say.
Yes, Your Honor. I would, at this time, defense would request to a 24-hour reset on this charge. Unlike the situation we had yesterday, this does not seem to be a clerical error or a missing page. This is a sworn affidavit from the officer claiming that he had probable cause for these two charges but was not able to establish the line for the second, and as such, I would request ROR as previously stated, Your Honor.
Okay. What I'll do, I'm going to give the state 24 hours. He's currently out on ROR on a trespass. I'll take no action on that.
Yes, Your Honor.
So he's able to postpone. He can postpone. The other issue I see is, quite frankly, ownership issue as to whether I can't quite make heads or tails of this charging affidavit, but I'll give the state 24 hours, but I'm not going to prevent Mr. Beaulieu from bonding out if he's able to.
Yes, Your Honor.
I have no money for that, sir.
All right. Well, I'll leave the bonds as is at this point. I've appointed the public defender. If you're unable to bond out, you'll see the judge again tomorrow.
Sir, may I just tell you I'll tell you the straight honest truth of what I did, what was going on.
You've got the right. You got the right to remain silent, sir. And at this point, it's not a trial. I'm not here to pass judgment on if what's in the affidavit is true or not true. So at this point, I'll leave the bond as is. If you don't bond out, you'll see the judge again tomorrow. But I'll take no action on the case that you're currently out on ROR on. So if you're able to make bond, you're able to bond out. Okay. Good luck, sir.
Thank you, Your Honor.
Roniel Caridad.
Your Honor, he is present and approaching, but this will be a matter for the Spanish interpreter.
Okay, I'll call the interpreter. Did they add interpreter?
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter. I have not been sworn in yet.
We swear in the interpreter.
Do you swear to translate from English to Spanish, Spanish to English, testimonies given?
Yes.
All right, good morning, sir. State your name, please.
Buenos días, señor. Indique su nombre, por favor.
Roniel Caridad.
¿Cómo, perdón?
Roniel Caridad.
Ramiel Caria.
Ro.
All right, sir, you're here for initial appearance.
Usted se encuentra aquí hoy día para la vista de primera instancia.
You've been arrested for the offense of petty theft.
Ya usted le han arrestado por la acusación de hurto de menor cuantía.
I'm going to appoint the public defender to represent you.
Se le designará defensor público para representarle.
Bond is set at $500.
La fianza se fijará en $500.
In addition, you're ordered not to return to the Walmart on Vineland Road in Kissimmee.
Adicionalmente, usted estará prohibido regresar a la tienda Walmart en la Vineland Road, Kissimmee.
Good luck, sir.
Buena suerte, señor.
Thank you, Madam Interpreter. That's all we have.
Thank you, Your Honor.
Got Rick Fortune.
He's present and approaching, Your Honor.
Morning, sir. State, please.
Rick Edward Fortune.
Mr. Fortune, you're here for initial appearance. You've been arrested for the offense of petty theft. I'll appoint the public defender to represent you. Okay. Bond is set at $250. In addition, I'm ordering you not to return to the Publix
Yes, sir.
on Blake Boulevard. All right, good luck.
Thank you, sir.
Mark Hunter.
Yes, Your Honor, he is present, if I may have one moment. Mr. Hunter? Is present and approaching, Your Honor. Defense does have a probable cause challenge to this charge.
Okay. All right, good morning, sir. State your name, please.
Mark Hunter.
All right, thank you, Mr. Hunter. You're here for initial appearance. You were arrested for the offense of arson. I'll appoint the public defender. Counsel, do you have a probable cause argument?
Yes, Your Honor.
Go ahead.
My client is charged under Florida Statute 806.01 arson. In particular, it requires that a person willfully and unlawfully attempt to, or in the commission of any felony by fire, explosion, damages or cause to be damaged, any building or other structure. I'm paraphrasing a little bit, Your Honor. As such, while reading the arrest affidavit, we see that a fire did occur, but the two witnesses, one did not see, well, neither saw my client light the fire. Only one saw my client, I believe, around the fire, and the only thing that he was attempting to do was to put it out and then ran away from it. That does not show that he attempted to light it or that it was even an intentional action. None of the facts point to anybody seeing him attempting to light this fire or, and even with him with a spray can of paint, which I believe the officer references was the ignition source for said fire. As such, I believe there's no probable cause for arson as alleged in this arrest affidavit, Your Honor.
The state agrees.
Okay. The state agrees?
Yes, Your Honor. The affidavit does indicate that the witness testified they saw him attempting to put the fire out.
Okay.
So.
All right, so the state's going to not find probable cause, and you'll be ROR'd on the case.
Thank you, Your Honor.
Casey Jonas.
Your Honor, I've been informed by corrections that he has refused to join us today. I believe, both from what I was told by corrections and from the arrest affidavit itself, that there may be some mental health concerns occurring, a possible mental health crisis. Defense would request a 24-hour reset.
All right, I'll just stay the bonds as is, and we'll reset for tomorrow.
Thank you, Your Honor.
Dexter Wallace.
Is present and approaching, Your Honor.
Good morning, sir. Your name, please?
I'm Dexter Wallace.
Mr. Wallace, you're here for initial appearance. You've been arrested for a battery. It's domestic related. I'll appoint the public defender to represent you. State, you have a position on bond?
Just within the schedule, Your Honor.
Okay, defense?
Defense would just request a reasonable bond towards the low end of the schedule, Your Honor.
All right. I'll set the bond at $500. I'm going to order that you have no contact with Raquel Rios or Rachel Rios, that you maintain a separate residence from her if you were living together to begin with. But you're not to live with her, no contact with her, and I'm going to order you that you not consume any alcohol or illegal drugs.
Your Honor, may I have one moment to inquire something of my client?
Yes.
Your Honor, they do maintain a residence together, and he has personal belongings he needs to retrieve
All right.
from that area. May
Okay.
I have a one-time return with law enforcement for my client?
Yeah, sir, you can return to the shared residence one time with law enforcement escorting you to get your personal belongings. You're not to go back there alone. You're not to have contact with her.
Okay.
Okay, good luck. That's straight bond.
Yes, Your Honor.
Okay, is that all we have this morning?
I believe so, Your Honor.
Have a great day.
You too. Enjoy the rest of your weekend, Your Honor.